We have done a lot of work here on 5AA going to bat for the Green family. We had Mark and his wife and daughter, Kelly and Rebecca, on the show yesterday in the studio. It was quite funny, actually. I went and did Sky News yesterday afternoon in the Advertiser building, and the lift opened as I was getting out on the fourth floor to go into the studio. There's Mark. So I began the day talking to him and finished the day talking to him. He'd just done an interview yesterday, one of more than 20, as his case receives saturation coverage. Well, in a legal sense, how good are his chances? We thought that we would talk to an immigration expert. Melanie McFarlane is an immigration agent. She's also the executive director of the International Students Education Agents Association. Melanie, thanks for your time. How would you rate the chances of the Greens staying in Australia?
I think, first of all, thanks for having me on. I think they have a very good chance of staying here because, it's a ministerial intervention. The minister has the opportunity now to let them stay, and there are so many reasons that they should do so. So many. The
fact that they've been working, not just Mark, but also Kelly. She works at Villiers Bakery. He's been an electrician, and he's only ever been out of work when the companies that had employed him had financial problems. And also their daughter has spent more than half of her life in Australia. Are things like that taken into consideration?
Yes, they absolutely are. It's not just anyone who can appeal to the minister. You have to have gone through a whole process. First of all, have your case refused at tribunal. But if you actually are already settled in Australia, you've been paying your taxes. And also, the occupation of electrician is a trade occupation on the medium to long-term skill shortage list in Australia. So it's clearly required here, and it has a pathway to permanent residence. So there's no reason why the minister shouldn't be giving him his permanent residence immediately, to be honest.
So why does it have to get to the point of ministerial discretion then, Melanie? It feels like, there's so many boxes are ticked that it should have just been approved and processed as a matter of course.
Yes, that's right. But the thing is, obviously, errors have been made along the way here. There could be various issues. It could be that he's slightly over the age now where he could apply legally for permanent residence if he's over 45, for example. If various mistakes have been made, it means that then his visa gets refused. It then goes to tribunal. The tribunal refuses it because they have no means within the law to approve it, even if they want to. So at that point, you have to take the case to the minister. It's called a ministerial intervention, and the minister needs to look at all the extenuating circumstances, including those that we've just discussed, being settled here, having a trade that's highly in demand, and look at the skill shortage we have here right now in Australia. And then the minister can make a decision based on his discretion.
And just finally, Melanie, one point that has been made by some who are quibbling about the process, they seem to be arguing that, well, hang on a minute, if the ministers set this precedent with the Biloela family and now they make an exemption for the Greens, it's taking this ministerial power in some sort of dangerously ad hoc new direction. My understanding, and correct me if I'm wrong, ministerial discretion has existed in immigration law for time immemorial, has it not?
That's exactly right. Yes, it has. So this is absolutely not a precedent. We have a client, for example, who works in the industry of childcare who had a medical issue, was first refused a visa, went to the tribunal, etc. That wasn't overturned. She went to the minister, and she's still here in Australia because she had a son who had grown up here. She works in the area of childcare, a lot of skill shortage there, and so it is absolutely not a precedent. This has always existed, and it should be now used in order to be able to grant the Greens family permanent residence in Australia.
It's very great plain English explanation, Melanie. We appreciate you sharing your wisdom on this topic with our listeners. Thanks for joining us.
You're very welcome. Thanks for having me on.
17 minutes to 9.
Good text on Tanya about this very issue, saying, Dave, you'll see overwhelming support in the Australians' comments section, but a few critics have assumed the family hasn't bothered to follow process, hasn't done anything about seeking residency for a decade, or hasn't filled out the form, so tough luck. Well, from what Mr. Green explained in your chat with him, I think, the hiccup is due to a lack of employment continuity for 3 years with one employer. As he explained, some of his solar industry employers closed up, so he had to start again. So no fault of his own. 100%, Tanya. That is a very, very good point.
You'd think there might be a few other people too that may have had their work disappear over the last 3 years, don't you? You know, like it's not unbelievable that the odd business has gone belly up.
No, exactly.
Anyway, let's hope the right thing gets ultimately done here.